Thank you very much, Jens. And it's such a pleasure to be here. And thank you very much, Philippe, for once again organizing a fascinating conference for us. When we were looking at the program for today's conference, and the question of the right to leave your country came up, I was very interested in convening this panel because a number of years ago, I wrote an issue paper for the Council of Europe Commissioner for Human Rights on the right to leave in the law of the Council of Europe. So in particular, looking at issues around the right to leave in Protocol 4, Article 2 of the European Convention on Human Rights and its interpretation by the Court of Human Rights. So this session provides me with an opportunity to look a little bit more widely at the question of what is the right to leave. And the key point, which I'm going to come back to, circle around and come back to again and again, about the right to leave as a right in international law, is the fact that the right to leave exists as a self-standing right and is not dependent on any right of entry anywhere else. So what I'm going to be explaining to you is how, starting from the Universal Declaration of Human Rights, Article 13(2), through the International Covenant on Civil and Political Rights, the European Convention on Human Rights, whether or not someone has a right to enter another country, whether or not they are a citizen or a foreigner, wherever they are, in whatever country they are entitled to leave, irrespective of whether they have nowhere to go which will admit them. So the right to leave is self-standing and does not depend on any right to enter another country. So that's going to be the big story, and that's where I'm going to lead you through as I present where we are in terms of international human rights law on the right to leave. So you have Article 13(2) of the Universal Declaration of Human Rights, which simply says everyone has a right to leave any country, including his own, and to return to his country. So you have two rights contained in Article 13, the right of anyone, citizen or foreigner, to leave any country, and the right of anyone to return to his or her country. I'm not going to go into the discussion and the opinion of the Human Rights Committee about the right to enter your own country and the extent to which that right may be a right which also applies to someone who is not a citizen. That's not the subject of today's discussion. Instead, what I want to do is look at how that right to leave moves from the Universal Declaration, of course, a declaration. We have the discussion in the international community, whether the Universal Declaration has now become a source of law in itself and the foundation of international human rights, as opposed to merely a declaration requiring subsidiary measures or secondary measures to be adopted. At any rate, for the right to leave a country, we don't have a problem because it's included in Article 12(2) of the International Covenant on Civil and Political Rights. Now, the right is not absolute. There are exceptions which are permitted. Restrictions can be made, but they must be provided for in law. They must be necessary, not just desirable, but necessary to protect national security, public order, public health, or morals, or the rights and freedoms of others. And those are the only exceptions. There is nowhere there in the exception to the right to leave the obligation that you must prove you have somewhere to go to, that you will be admitted somewhere else. So the only exceptions are the ones set out in Article 12.2 of the 12.3 of the International Covenant on Civil and Political Rights. And these exceptions must be applied consistent with other rights recognized in the Covenant. The ICCPR is a very, very popular convention. It's been ratified by 169 countries. So among the real successes of the UN system, all these countries have accepted the duty of Article 23.2. And in the European setting, we also have Protocol 4, Article 2, which includes the right of everyone to leave a country. I want to turn briefly to the sources of interpretation of the International Covenant on Civil and Political Rights in particular, which is, of course, the Human Rights Committee, which is empowered to produce general comments which apply to all countries which have ratified the convention. And then I'm going to turn briefly to the additional protocol, the optional protocol to the International Covenant on Civil and Political Rights, which creates a dispute resolution mechanism, the complaint system to the treaty body, the Human Rights Committee. Individuals who've exhausted domestic remedies can apply, can make an appeal, can make a complaint to the Human Rights Committee, and the Human Rights Committee will carry out an investigation, a hearing, and produce an opinion, which increasingly is considered to be a form of quasi-judicial judgment on the case. And I would just say there that of the 169 states which have ratified the International Covenant on Civil and Political Rights, 116 have ratified the optional protocol, and that includes all countries in the Council of Europe, with the exception of 3, and we have Greece, Switzerland, or 4, Turkey and the UK, that have not accepted the jurisdiction of the Human Rights Committee to hear complaints under the ICCPR. But the first step is, what has the Human Rights Committee said about the right to leave? And in the General Comment number 27, which was issued in November 1999, so 10 years after the fall of the Berlin Wall, much of the early discussion about the right to leave was about obstacles placed by countries in the Soviet bloc on their citizens leaving. So 10 years after the end of that regime, the Human Rights Committee considered it necessary to issue a general comment on the scope of the right to leave in the International Covenant. And the first and most important part for our consideration is paragraph 8 of that general comment, where the Human Rights Committee opines that the freedom to leave the territory of a state may not be made dependent on any specific purpose, so you can leave irrespective of why you want to leave, or any period of time the individual chooses, so there can be no limitation because the person intends to leave for a day, a week, a month, the rest of their lives, or to stay outside the country. Thus, travel abroad covers departure for a short period and for a long period. In paragraph 10, the Human Rights Committee states that it is very important for parties to report on their practices which create restrictions on the right to leave, which they apply to both nationals and to foreigners, and information on measures including those which impose sanctions on international carriers. The Human Rights Committee does not accept, in the general comment, that the right to leave can be made subject to a right to enter another country, and therefore carrier sanctions are subject. Now, one of the things which I think would be an extremely valuable exercise for us to undertake in terms of research is to look at the Universal Periodic Review. We're going into the third cycle. France and 10 other countries were examined at the end of January in this peer process in the UN, where all of the treaty bodies' comments on problem areas in respect of the application of the treaty obligations, the human rights treaty obligations of member states are considered, and questions are posed to countries. And if you look on the UN website, you will see in the examination of France under its periodic review last week, Portugal asked a number of questions about border controls and their application in France. I haven't yet seen the answers, but they include questions on Article 12. We've now had 3 cycles of universal periodic reviews of countries, and I think it would be a very valuable research project to look at how often Article 12 has come up now in those periodic reviews and what questions have been asked of which states with what kinds of answers. The question about whether or not states can leave is a matter of great concern for the Human Rights Committee, and it comes up in a number of decisions by the Human Rights Committee in individual cases which come up before it. There haven't been that many. The most recent one is from 2009, which came before there are 2 that came up in 2009 before the committee. But the committee has found violations of Article 12 in 3 of the 4 cases which have come before it, and the reasons are obstacles to leaving. In one case in particular, in respect of Libya, where the Human Rights Committee finds that Libya has violated its obligation under Article 12.2. It was obstacles placed in the way of a woman and her children who were seeking to leave Libya to join their husband and father, who had been granted international protection in Switzerland, and Libya was not allowing her to leave. So the fact that she was going to join someone who had made claims against Libya for profound human rights abuse so severe that the country where he was then living had provided him with international protection is not a reason to interfere with the right of first-degree family members to leave another country. I'm going to wrap up very briefly with a quick look at Protocol 4, Article 2 of the European Convention of Human Rights, and what the European Court of Human Rights has done in respect of that provision. Here we have a lot more judgments of the European Court of Human Rights. There have been a lot of complaints brought before the court in respect of the right to leave. In fact, there are 18 cases which have been considered on the merits by the Court of Human Rights. The vast majority of those cases, the first ones start from 2002, the most recent ones are from 2012-13. But what's interesting about these cases is the majority of them are from countries which were in the Soviet bloc and are about obstacles. The most important one, I think, for our purposes that will bring us back to some of the issues that will come up here is the Stahma versus Bulgaria case of 29 November 2012. And in this case, the Bulgarian authorities had refused passport facilities to one of their nationals who had been expelled from the United States. The individual sought a remedy. He wanted to travel. He needed a passport in order to travel. as both the Human Rights Committee and the European Court of Human Rights have held, passport facilities are an inherent part of the right to leave a country, and the Bulgarian authorities refused to provide him with a passport. In respect of the grounds for that refusal, the Bulgarian authorities revealed that they had been requested by the US authorities not to give him a passport because, in the view of the US authorities, he was likely to seek to try to re-enter the US, where his mother and stepfather were living. He was someone who had been refused family reunification. And therefore, it was at the request of a third state that Bulgaria refused passport facilities to Mr. Stamos. The Court of Human Rights found that this was a breach of his right to leave Bulgaria. It was a breach of Article 2, Protocol 4 of the European Convention on Human Rights, that the interest of Bulgaria in acceding to the request of a third state to prevent its citizen from leaving was not a justification to prevent that person from leaving, and was certainly not a justification for providing a passport to that person. And the reasoning of the Court of Human Rights was that to prevent the person from leaving prevented that person from going anywhere in the world, not merely to the United States, that the entitlement to leave is not tied to the right to enter anywhere. The right to have a passport and leave a country is not dependent on whether or not some other country is concerned you might turn up on their shores. So in the context of the current scenario, we have heard just now Mr. Perdue speaking about the externalisation of migration controls as the yeti that the EU has never quite seen. Perhaps we can see that the yeti of trying to get other countries to prevent people who are present on their territory regularly or irregularly from leaving is not only a yeti that we have trouble seeing, but it is also an objective which is contrary to the obligations of all those member states which have ratified Protocol 4 of the European Convention on Human Rights, which does not include Switzerland, the UK, and Greece, but does include all the others, and is contrary to the obligations of those member states. If we see Article 2, Protocol 4, and Article 12 of the ICCPR as being consistent rights which need to be interpreted in a coherent fashion, attempts to encourage states to prevent people from leaving their territory will be a breach of both the ICCPR obligation of states around the European Union, as well as in respect of Council of Europe and non-EU countries such as Turkey, a breach of the obligation under Protocol 4 of all Council of Europe countries. Thank you very much for your attention.